Good morning, this is Mr. Nunez, if you'll mute your YouTube. Good morning, this is Judge Elisa Perez presiding over the 210th District Court Civil Docket for June 26, 2024. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. Mr. Nunez, would you call our first case, please?
Give me a second, Judge. Let me mute. It's muted. Muted. Okay. Yes, ma'am. Page 1, top of the page. Calling cause number 2023 DCV 2262 Omar Chavarria versus Crystal Belmontes. Announcements, please.
Hi, good morning. Paul Savina for the plaintiff.
Good morning, Your Honor. Raymond Bass on behalf of the defendant.
Okay, I think this has probably been reset before on an entry of judgment. Mr. Savinoff, do you have an update?
So, Your Honor, this case has settled. We've received the settlement release, which we signed and we sent to defense counsel along with the drafting instructions on May the 24th. So we're just waiting on the settlement check. Once we get the settlement check, we'll non-suit.
Can I put you on? I misspoke. This is the first entry of judgment. Sorry. When I see those, I always assume there's probably been a few before. Can we reset this for about 30 days or do you need more time than that?
I think 30 days will be fine.
Okay. Alrighty.
And Your Honor, sorry, briefly, if I could just speak to Mr. Savina. I don't have the release, so I just want to confirm that it was sent to me because my last email shows that we still don't have it.
Okay. Can you check?
I can personally email it to you right now, but I'm just looking through our notes. I show that my assistant sent it on May the 24th. I can double check on the email, but if you say you haven't received it, I'll just resend it right now.
Perfect. Thank you.
Okay, so we'll reset for 30 days. Thank you, Mr. Baeza, Mr. Savinoff. We'll see you.
Thank you, Your Honor.
Or not in 30 days. Bye-bye.
Thank you.
Bye-bye.
Who's next?
Judge, same page. The calling cause number 2022 DCV 1240 Gabriel Alvarez versus Jessica Sinfon Rodriguez et al. Announcements, please.
Hi, good morning, Your Honor. Bernie Gonzalez for the plaintiff with Caribbean Shaw in San Antonio.
Good morning, Your Honor. Udi Heller for the defense.
Good morning, and entry of judgment as well?
Yes, Judge. We have settled this case, and we had to replace the check because the first one sort of got misplaced in the mail. But Mr. Heller has assured me, he's on right now, and he's assured me that he's overnighting the replacement check. So I'll non-suit the minute I have it, Judge.
Okay. Well, we'll do the same thing 30 days out. If we have our dispo documents, then I won't see you in 30 days.
Yes,
good luck.
thank you. Thank you,
Take
Judge.
care.
Thank you, Judge. May I be excused?
You are. Thank you.
Thank you, Judge.
Are all of the expunctions taken care of, or are we still pending one?
Berna said we were clear on all of them, Judge.
Okay. All right. Who's next?
Next, same page, Judge. Calling docket number 2024 DCV 0117 U.S. National Trust, U.S. Bank Trust National Association et al. Versus Isabel Pineda Gatewood et al. Announcements, please.
Yes, George Sherry appearing for petitioner U.S. Bank.
Give me 1 second. I feel like I had an email on this case, so I want to make sure I. Okay, no, I thought I did. Let me see, Mr. Scherer, good morning. We are set for our default hearing. This has been reset, I believe, in the past for notice to be sent out. I just want to confirm no one here on behalf of Pineda, Gatewood, Isidra. Okay, Mr. Scherer, you may proceed.
Okay, thank you, Your Honor. First off, This is a Rule 736, excuse me, application for expedited foreclosure. We're not seeking any type of money damages. We're simply seeking an order to set this for a foreclosure sale that doesn't get paid according to Article 16, Section 50A6 of the Texas Constitution. I would ask the court to take judicial notice its following contents, including the note and the deed of trust that were signed by Ms. Gatewood back on March 13th of 2009. There has been a default on the loan payments. There's been notices sent to cure this, and the default has not been cured. And so this morning, Your Honor, we are asking, and by the way, Ms. Gatewood was served on this back on January the 24th of this year, and there's been no response filed on it. So we were asking the court to enter a judgment allowing the non-judicial foreclosure.
The court will take judicial notice of all the documents in the court's file, as well as the attachments to your motion. The default is granted. I want to say, I thought I had received some type of proposed order on this in the past couple of days, but as I did a quick scan of my email, I don't see it there, Mr. Scherer. So if you wouldn't mind resending that order, it'll just make things a lot quicker instead of having us look around.
Where do I need to send the order?
Send it to Ms. Hernandez. So that's my.hernandez@epcounty.com.
Absolutely. Sorry,
All right.
kids. All right. I think, Your Honor, I have nothing further.
Thank you very much. You're excused.
Excuse. Thank you. Have a good day.
Sorry, Deborah, I was getting through that and I saw we were both struggling. Okay, let's go to the next one, please.
Yes, ma'am. Calling cause number 2022 DCV 0396. Cecilia Moreno versus Ariana Murillo. Announcements, please.
Scott Brooks on behalf of the plaintiff Cecilia Moreno.
Sebastian Uribe on behalf of the defendant Murillo.
Uribe. Good morning, gentlemen. Final civil pretrial. We've got our docket call and jury trial end of July, August. How are we doing on this one?
Your Honor, I think we're doing pretty well. We got depositions already taken care of and mediation done.
Okay.
And so I think we're going pretty good. We just know if we have a demand out, if we can't get it done, then we'll get the expert depot set, but I don't see any issues.
Okay. If you've already done mediation, then that's kind of the deadline was yesterday. So thank you for doing that. Obviously, if we hear from you before the 31st, great. If not, we'll see you at docket call. Okay.
All right. Thank you, Your Honor.
Thank you, gentlemen. Have a good day. You are excused.
Thank you, Your Honor. Have a good day.
Okay. Who's next?
Next, Judge, page 3, top of page. We are calling cause number 2022.
Mr. Nunez, can I stop you 1 second? Do we have anyone here on 0487? Felix Alvarez? Okay, all right. Okay, sorry, go ahead.
It's going to be page 3, top of page, calling cause number 2022 DCV 0886 Eduardo Carvajal et al. Versus My Universe Inc. et al. Announcements, please.
Good morning, Your Honor. It's Brendan Villanueva here on behalf of the plaintiffs.
Carlos Rincon for Landstar Ranger.
And Brian Cathy for Landstar Ranger as well.
Elena Esparza on behalf of Expeditors, Your Honor.
Sean White on behalf of RV Share and Defendant Jackson.
Good morning, everyone. We are scheduled today on plaintiff's motion to compel the deposition, I guess, of the Landstar representative. I had reviewed plaintiff's motion, but I'll hear any argument on that. But Mr. Rincon, your response, I did not have time to review yesterday since our docket didn't finish until well after 5 o'clock, if I'm not mistaken. Well, let me see what this is. I received Hand delivery, yeah. The hand delivery we got yesterday, I did not review. Okay, so let's go ahead and get started. Mr. Villanueva?
All right. Your Honor, Mr. Scott Ray was presented as Landstar's corporate representative in February. There are 4 specific topics that we questioned him on that Mr. Rincon instructed him not to answer. So just very briefly, those 4 topics are regarding his communications with Little John and what he would have expected. The second one was regarding insurance and indemnity agreements. 3 was regarding seatbelt use in RVs. And 4 was the issue of unlawful or double brokering. So to start with the first general topic that Mr. Rincon instructed Mr. Ray not to testify to, and the basis for, I believe, the instruction and the objections is that they were not properly covered in the topics. So first, the question that was asked by Mr. White to Mr. Ray was, what would you expect from your agent, Little John, to tell you about this crash? Would you expect him to tell you that somebody died, that somebody was paralyzed, and so forth? Mr. Ray answered, I would want to know the severity. And then Mr. White asked why. And then that's when Mr. Rincon cut it off. The topics are clear here. In topics 15 and 18, 15 deals with communications between Landstar and its agent. Landstar, in its motion that it filed yesterday, agreed that Little John was an agent of Landstar and negotiates business on behalf of Landstar. And so Mr. White was asking about what communications they would have, which falls under 15. And also topic 18 deals with the investigation of the incident. And so again, that would deal with, well, what did you do? What would you expect to have found out? Mr. Rincon object to this and instructed him not to answer because he believes it's a hypothetical that is not covered in the topics and that it is improper. However, when you have a principal-agent relationship, it's natural to ask, what would you expect? What would you expect? You could ask a supervisor, what would you expect of your worker? You could ask a partner, what would you expect of your associate attorney? Those things are natural. Here we are asking the principal, Landstar, what they would expect to have been told by their agent, Little John. And we need to know that because we need to know what sort of knowledge that Landstar had of this incident and what actions that they took. So I think 15 and 18 directly address these questions and they should be allowed to answer, not only because it's communications between the principal and agent, but also because it has to deal with the investigation of the incident. Topic area number 2, that deals with questions regarding insurance and indemnity agreements. The questions weren't really asked. Basically, Mr. Rincon said Mr. Ray is not prepared to handle any of those topics and that he wouldn't be able to. We asked if Mr. Rincon would present somebody from Landstar that would be able to do that. He said no, he never does that. He hasn't had such a request. Landstar, in its response, relies on a case, Enri Dana, for the proposition that depositions aren't allowed to discover insurance and indemnity agreements. However, that is not true. If you look at the case that was actually cited by Mr. Rincon, eventually they allowed that deposition to go forward, and it held the trial court's order does not specifically address policy erosion. Rather, it merely orders Dana to produce a knowledgeable witness for deposition to testify regarding such insurance policies. Because the witness may be needed to prove up the contents of the policies, and the plaintiffs are entitled to ask questions relevant to the subject matter of litigation, we conclude that the trial court did not abuse its discretion in ordering Dana to produce a witness for deposition. So with regards to the facts of our case, it is even stated in the deposition that he wants to know, you've made an indemnity claim. Who are you claiming to indemnify? On what basis? How much are you claiming to indemnify? Indemnity agreements are included in the provision that allows us to discover insurance agreements. And so Landstar has not specifically addressed indemnity agreements, but that was one of the things we mentioned in the deposition that we wanted. The plaintiffs have the right to know who's ultimately going to be paying for a judgment, if any, or if we're going to have settled negotiations, who are we negotiating with? Also, Landstar has a multitude of different entities. The corporate representative testified he's paid by Landstar Transportation Logistics. The defendant in this case is Landstar Ranger. The service provider agreement between two defendants in this case names 6 different Landstar entities. We think we are entitled to have some guidance. What entities do these policies cover? Do these policies cover entities that owe indemnity to Landstar Ranger? Is that how we're getting to the policies? Just saying, hey, we produce the policies, you figure it out. That is not written anywhere in the rule. The rule states we can discover, we can use discovery. Discovery is interrogatories, requests for reductions, depositions. That's included in discovery. So we think that for that topic, Landstar should produce a witness that can answer these very basic questions. These are questions that aren't outside the scope of discovery, as Landstar will contend, because we're asking not communications between a lawyer and Landstar. We're asking for, hey, who is going to be liable to pay this? Who are the indemnity issues with? Those types of things. And I think that goes to the subject matter of the litigation. The third issue I want to address is seatbelts. This incident is just, it's tragic. There was 11 people in an RV that were struck by a tractor trailer. Unfortunately, one died, and a lot of them were severely injured. Landstar's position is they weren't wearing seatbelts. I just got done presenting 2 witnesses in the last week in this case for Mr. Rincon to depose. It's not an exaggeration to say at least 15 to 20 questions, and probably more, dealt specifically with seatbelts. Okay. And it wasn't just, hey, when you ride in a car, you always wear seatbelts. There were hypotheticals. If you knew there were seatbelts, would you have worn them? You know, if this happened, would you have worn a seatbelt? Aren't seatbelts meant to protect you from this? A multitude of reasons. We asked one question to Landstar's corporate representative. Have you ever ridden in an RV? Did you wear a seatbelt? And then all of a sudden, those questions were cut off and they were instructed not to answer. Well, topics 25 and 26 relate to Landstar's defenses in this matter and Landstar's claims for plaintiff's comparative negligence. Okay, seatbelt is one issue. Landstar has not made that a secret. Okay, it's very well known they are going to blame my clients for not wearing seatbelts. So why can't we ask the Landstar corporate representative about his seatbelt use? I have to field, multitudes of questions of that for, the upwards of 8 people that are likely to be deposed in this case. And we're simply asking Landstar to provide a witness to provide its factual basis for claiming our clients were negligent for not wearing seatbelts. So I think that issue is, pretty cut and dry. We're not asking for, anything that I think is outside the scope of discovery. You say we should wear seatbelts. Well, why? Do you wear seatbelts? I think those questions are normal, and those are questions I think are asked in pretty much every litigation that involves seatbelt use. And then lastly, number 4, this one is probably the topic that is going to be up for debate and has the most moving parts here, but it's the issues of unlawful and double brokering. I would just like to point out to the court that topics 13, 20, 23, and 24 deal with state and federal regulations regarding the transportation of this load. For instance, topic 13, applicability of the federal motor carrier safety regulations to the subject load. 20, all state and federal regulations in existence at the time of the crash. 23 and 24 were lawsuits that were filed against Landstar for unlawful and or double brokering. And so Mr. White, in the deposition of Mr. Ray, confronted him with several industry publications that talk about this double or unlawful brokering dilemma. Okay, it's something that we believe is rampant throughout the trucking industry. It is something that has been written and published about. We want to know, what is Landstar's knowledge of that? Did they know that there are federal motor carrier rules about unlawful brokering? That's definitely one of the topics, the applicability of the rule. That also goes to notice and knowledge. We need to know that because we need to know for our gross negligence claim. What did you know? Did they know it was unlawful? Landstar, in its response, it says, well, this is moot because it's not double brokering. Expeditors presented a corporate representative. They're another defendant in this suit. And that representative said they're not a broker. They don't have a broker license. They're a freight forwarder. So therefore, it's no double brokering. So why even ask questions about that? Well, one, just because one witness says something does not mean that all of a sudden all discovery is going to cease. And I will grant you that Mr. Rincone's would agree that, hey, just because my client says something doesn't mean he can't go do discovery. To the contrary, it's a credibility issue. Was Expeditors corporate representative correct? And we are allowed to ask Mr. Ray what his factual knowledge is of double brokering. And then also to that issue, just because a witness says, well, we're a freight forwarder, not a double broker, does not mean that they weren't doing the same actions. The actions of a broker is essentially to arrange to hire motor carriers to transport loads. All right. That's what Expeditors did or attempted to do. And that's what Landstar claims it was only doing in this case. So when you break it down to just factually, you see double brokering right there. You have two companies that say we're responsible for hiring the motor carriers. So, we need to figure out, who's on first, who's on second sort of thing. And just because one witness has said, oh, well, we're just a freight forwarder, does not disclose any discovery into the unlawful or double brokering. And lastly, the articles, not only do they talk about the notice and knowledge of Landstar, but also to what their knowledge was about, whether it's unlawful and whether it's going through in the industry. And also too, some of those articles were specifically about Landstar or included Landstar in them. Does Landstar receive notification of this article? Is it going to dispute them? Our experts may rely on those articles. So we need to have a factual basis of what they're going to say regarding that. And I think those questions are allowed. And then the last argument I will make with regards to this whole issue as a whole is that we're talking about discovery. We're not talking right now about admissibility and trial. So it's a little tough to defend these issues because we didn't get any answer from Mr. Ray. He wasn't allowed to give any answer. So I can't come up and tell you, well, Mr. Ray said this, and this is why this discovery is important. Right now, we don't know because Mr. Rincon has cut off those questions. So what we are asking for, Your Honor, is that Mr. Rincon produce a witness on behalf of Landstar that can address these four topics that were not allowed to be addressed in his deposition. Thank you.
Right, and Mr. Van Wyl, I apologize, as I had Odyssey open and I was just confirming that Mr. Rincon's pleading was filed. I see that you had filed an additional reply, so unfortunately I didn't review that, but thank you. Mr. Rincon, you may proceed.
Good morning, Your Honor. May it please the court. Am I free to proceed? I thought somebody was trying to weigh in.
No, I think just you, Mr. Rincon.
Okay. Your Honor, this deposition of Mr. Scott Ray was taken back. I want to give the court the precise date. It was taken back on February 8th of 2024. And if Your Honor recalls this case, getting discovery out of Expeditors, which is a freight forwarder, has been an uphill slog. But the reality is that since Mr. Ray's deposition was taken, the factual landscape of this lawsuit is completely changed and it's different. I was the only person at that deposition that is here before you in this hearing. I sat there with the witness, and one of the first misstatements I must clarify is I never instructed this witness to not answer a factual inquiry. The only questions that I asked the witness not to answer were two types, and it was a total of 4 issues that came up. Number one, hypotheticals that were clearly beyond the scope of the notice. We would not have been able to prepare for that, and it would be inappropriate to have to produce a party non-expert witness to respond to hypotheticals. And number two, questions in the insurance realm that have to do with insurance coverage. So I want to immediately upfront remove any type of misconception that I was in a deposition room instructing a witness not to answer a whole bunch of questions. There were a total of 4 questions or 4 points that were brought up. And in each of those instances, I did not instruct the witness not to answer other questions. They could have asked hours of factual questions on any one of these topics had they so wanted. But the reason it shut down is that they were wanting to ask hypotheticals that weren't on the notice and would be just structurally inappropriate of a lay witness. And second, questions that called for a legal conclusion in the realm of insurance. So right off the cuff, I believe that on the merits of the objections that were raised to the deposition notice and what was stated in the record at the deposition supports the objections, and those objections that I made should be sustained. Now, counsel chose not to pursue other fact questions that he could have pursued. I don't know why. We had plenty of time. The deposition went 3.5 hours. He had 2.5 other hours. I was in Rockford, Illinois, and was ready to stay the night. I can't tell the plaintiff's lawyers or the opposing counsel to ask questions they're entitled to ask. That's their judgment. He decided not to ask factual questions. I think what happened is afterwards, maybe there was some indication or sense that there was a lost opportunity to make some inquiries and they want to get back. But I never instructed this witness not to answer a factual inquiry. And so just point number one. Point number two, the deposition notice had 28 very comprehensive topics. I objected. I raised legal objections, and they're on file with the court to a series of those. But there was a lot of inquiry made of this witness that is not before you. And there was a lot that went on at this deposition that you're not having to pass judgment on. And so I want the court to understand that this was a very robust, productive deposition. And what we are left with, really, I view as being 3 argumentative hypothetical issues that Your Honor wouldn't allow if it was asked of a witness in court. And it would be inappropriate to do so of a corporate representative who that the rules require be noticed in a form of a topic. Those hypotheticals were clearly outside what the rules required the plaintiffs to notice. And then this issue with the insurance, and I'll get to it briefly, but number one, the only question relative to this Little John, so Your Honor has an awareness, Little John is an independent sales agent for Landstar. They have offices various places and in Mexico. And what happened is that Expeditors had a load of freight that needed to be moved from Guadalajara to the Sacramento area in the United States. Well, Expeditors, they coordinated completely the transport of the freight from Guadalajara to Laredo. And then Landstar, through its independent sales agent, Little John, coordinated and brokered the load to my universe, who picked up this freight in Laredo, Texas, and tragically was involved in this accident in El Paso. The only question relative to the investigation and Little John that I instructed this witness not to answer was one that was both not noticed in the list of topics, and it was inappropriate, and it is. And I cited it for you specifically, Your Honor, in the text of my response. It is one question where Mr. Ray, it's actually a series of questions. Let me just read it into the record by Mr. White. What would you do if you were an agent? Question mark. Would inquire, hey, was it your fault? Question mark. Did anybody die? Did anybody get paralyzed? Did anybody get burned? Anything like that? And even subject to that, my objection, I allowed him to answer that question. But when the questions continued in the hypothetical realm, where the witness is being asked to step into the shoes of another party that is not Landstar Ranger, I instructed him not to answer. Now, Mr. White could have spent 2 hours asking Landstar Ranger everything it did following notification of an accident, who was called, who was written, what phone calls, emails were sent, what authorities were contacted, et cetera, et cetera. But none of those inquiries were made. And I don't know why, but he made a strategic decision not to go down that route. So when you look at the text of the deposition, I only instructed Mr. Ray not to offer answers in a hypothetical nature as to what Little John would have been thinking or doing. That's completely outside the scope of the notice and outside his personal knowledge as a corporate representative. Secondly, the issue of double brokering. Your Honor, there is a topic on double brokering, but what drew the objection, and Mr. White could have asked Mr. Ray a multitude of questions, any question he wanted about Landstar Ranger's understanding of double brokering, how it runs its brokering operations, etc. But what drew the objection was not that. It was that Mr. White had a stack of 6, 7, or 8 magazine articles or academic publications from trade magazines, where he was going to start down a path of asking him a series of hypotheticals about what other people believe involve double brokering to be and what the consequences are, etc. Now, these publications had not been produced, and I don't even think that that's really a point of heartburn. I think that if you're going to my corporate representative is not an expert witness. He's not going to be offering opinion testimony in the realm of brokering. Your Honor would shut that down in court in a heartbeat. And in the deposition, I understand it's discovery, not admissibility, but we're guided by a deposition notice. And these types of hypotheticals to a lay witness were completely inappropriate. And again, I want Your Honor to be clear on the fact that Mr. Ray could have received any question counsel posed on double brokering regarding his understanding on behalf of Landstar, what that is, how that functions, what is done to prevent it, how that can occur. They didn't go down that path at all. Instead, what he wanted to ask about were a series of hypotheticals on magazines. Of course, I'm going to object to it because it's outside the notice and beyond what the scope of a lay witness is. Number 3, insurance. Your Honor, I imagine, and I don't want to be presumptuous, but I imagine that automotive liability cases in El Paso County probably occupy a big percentage of the total docket. What the plaintiffs are arguing in this instance is that anytime a lawyer like me is down defending a car accident case, and I've got a client who's a defendant in a car accident case, that client can be grilled and examined in a deposition about his or her insurance coverage. And if they had an indemnity agreement with an employer or something, they can be grilled about the scope of those indemnity agreements. That clearly calls for a legal conclusion. Now, can they ask the party, who's your insurance broker? When did you, who did you contact? What is your, you produce these policies. Did you gather all the insurance policies that you felt were responsive to this discovery request? And Your Honor, I've been a lawyer for 35 years. I have never once, even once, whether it's a commercial enterprise or an individual, been asked to produce a witness to respond to questions regarding insurance coverage. And the way my practice has gone has been validated by the Texas Supreme Court in the case of In Reina Dana Corp. And it says in the opinion, we also conclude that the plain language of Rule 192.3F, which is the disclosure rule requiring insurance disclosures, by itself does not provide a sufficient basis to order discovery beyond the production of the existence and contents of the policy. You go further down, the specificity prevents our construing the rule by itself to require additional discovery about insurance coverages. And it cites to another Texas Supreme Court case, Missouri Pack Railroad Company versus Cross, 501 Southwest 2nd 868 at page 872. It's a Texas Supreme Court case of 1973. And the In Re Dana Corp case is a Texas Supreme Court case, good law. It's a 2004 opinion. It's the legal standard. Now, reference to, well, there may be instances where insurance coverages are fair game in a tort case. Potentially, if it's a different kind of tort case, like a first-party insurance case where there's a declaratory judgment and you have insurance coverages, you have indemnity issues, you have tenders of defenses at issue. Many times, those types of cases boil down to battles of the legal experts, both sides with insurance contract and insurance regulatory lawyers offering differing opinions. But Your Honor, the Texas Supreme Court plainly states that getting into enforcing a lay witness like Mr. Ray would have been on behalf of Landstar Ranger to answer questions that are clearly within the insurance coverage realm is inappropriate because it calls for a legal opinion. And what the rule requires, as the opinion says, is the existence and the contents of the insurance. And Your Honor, Landstar Ranger produced a large volume of insurance policies. I mean, these plaintiff lawyers are very sophisticated. This isn't their first rodeo. They know how to construe an insurance tower lots better than I do. And what I have done historically is I produce the insurance and let somebody else, some expert, figure it out. But that's not the role of the party. So our objection is valid. Finally, Your Honor, with respect to the seatbelts, the only question I directed Mr. Ray not to answer relative to the seatbelt issue, because he was asked some questions about RVs, but was, let me see here. It related specifically, and I have it cited in my response, and it's in the response at page 7. I list out the testimony. This was at the very tail end of the deposition, page 163. He's asked about his own personal use of seatbelts in an RV. Well, first of all, Mr. Ray's not a party. He's not a party. He's just not a party to the case. And so his use or usage patterns of RVs and seatbelts, as interesting as that might be, is completely not relevant in the case. And it's outside the notice, as it should be. And it would be derelict in my duties not to instruct him not to answer. But here again, to the extent counsel felt that they had properly asked questions about RVs, and that's not what Landstar Ranger's business is, they could have gone into it, but that's the only question. I just asked that line of question, his own personal use of seatbelts and RVs. And I want to close, Your Honor, by saying two things. You know, this is an important case. The plaintiff's motion to compel cites no law for Your Honor to consider, just lawyer argument. The defense brought you law on the one issue that's really serious is this insurance issue. And it's the stated law in the Supreme Court of Texas. That's worth noting. Second, you know, as I said, this motion to compel was filed back, I believe, in May. But when it was filed before a corporate representative deposition that Your Honor ordered be taken. And in my response, I cite to the unrefuted, and I'll tell you, I'll submit to you respectfully, the unrefutable testimony by the corporate representative for Expeditors, who says two things under oath that just ends this double brokering issue in this case. One is that Expeditors is not a broker of freight. They are a freight forwarder. So in order to do double brokering, you must have two people doing brokering work. And the only broker in this case, the only freight broker in this case, the only licensed freight broker in this case is Landstar Ranger. And then the second, to nail that thing into the ground, I asked them point blank, do you even have a broker's license? This is one of the largest freight forwarders in the world. To which he said under oath, no, he didn't. Now, they wouldn't have known that, I suppose, before they filed this motion to compel. But I can understand a lot of questions on double brokering, it's discovery. That's not what went on here. They wanted to get into specific hearsay articles, publications, to ask hypotheticals that was completely outside the scope of the notice. Each of the objections that I made were well-grounded. I never instructed a witness to not answer a fact question. They had plenty of opportunity, more than 2.5 hours, to ask more questions. They didn't avail themselves of that. I believe, truthfully, Your Honor, this is just a bullying tactic. They just want to ruffle Scott Ray's feathers again. And Yabasta, we've produced him. He responded and he answered all the questions, fact questions that were asked of him. So we'd ask respectfully that plaintiff's motion to compel the continuation of Mr. Ray or Landstar Ranger on the topics, the subject of the motion to compel, be in all things denied. Thank you.
Thank you, Mr. Rincon. Mr. Villanueva, do you have anything else?
Yeah, just a brief rebuttal. Your Honor, one thing, Mr. Rincon has talked about all the questions that we could have asked. All right, we're not going to ask questions just to ask questions. All right, we're very direct in what we want to do. And the questions we want to ask has to deal with these 4 topics that he was instructed not to answer. I don't care what we could have asked or what we didn't ask. We're not asking the court to go back and ask him all the things we didn't ask or what Mr. Rincon thinks we should have asked. We're asking you to allow us to question him on the 4 topics that Mr. Rincon instructed him not to answer. Second thing, Mr. Rincon has brought up a lot about hypotheticals and hypothetical this and hypothetical that. Well, let me tell you, Your Honor, if Your Honor rules in Mr. Rincon's favor, we're taking a deposition today, and I guarantee you, because he's done it already, he's going to ask my client hypotheticals. What would you do if you knew the seatbelt was there? What would you do if this happened? What would happen if this happened? And let me tell you, Your Honor, I'm going to instruct her not to answer because they are proper hypotheticals. And I want the court to understand the quote in Mr. Rincon's response. he writes, beyond that, inquiry in the form of a hypothetical to a lay witness in this compound form is improper. And I will tell you, when I instruct my clients not to answer, that's the basis I'm going to use. And I'm going to hope if the court rules in Mr. Rincon's favor today, that it would be consistent, because that's setting a precedent right there for this case. Mr. Rincon has asked plenty of hypotheticals to my plaintiffs, and I have allowed them to answer it all. Secondly, he talks about In re Dana Corp as far as the insurance agreements. I've already addressed that. I can provide that to the court if you want, but here's the end all be all. The court allowed the deposition on regard to go forward on the insurance agreements. They said, yes, you can prove up the insurance agreements through a deposition. I don't believe that they are legal conclusions, as Mr. Rincon stated. What is the basis for an indemnity agreement? Is this all the insurance there? Does one of these entities have an indemnity agreement with the other? That's a fact question. Who, what, and where. We're not asking to make a legal conclusion whether the agreement's valid or, whether this can hold up in the court. We can do that with Your Honor, because that's a question of law. As far as discovering the existence and the factual basis of things, I think we're allowed to do that. And then lastly, as far as the double brokering, Your Honor, he says, Mr. Rincon says that we've already got a deposition testimony, case closed. Well, I'm allowed to go. He says it's unrefuted, but yet I can't do discovery that may refute that. So we're allowed to ask multiple questions. If my client said something, Mr. Rincon's gonna dispute that. He's gonna ask other witnesses about that. He's gonna try to corroborate that through other witnesses. We should be allowed to do the same thing. And then lastly, with regards to the seatbelt issue and the personal use, I can't ask Landstar, the company we sued, whether it uses seatbelts in RVs. Just can't. It's a company. It can't physically use an RV seatbelt. This is the closest we're ever going to get to it. All right. This is the closest we're ever going to know as to Landstar's, personal views of this seatbelt issue in an RV. So that was the question that was asked. He was the corporate representative. He said he's ridden in an RV. He even said he was seatbelted. All right. And then the questions stop after that. So Mr. Rincon allowed him to say, yes, I've ridden in an RV, and yes, I've been seatbelted, but wouldn't allow any other questions. So we got the good stuff in, but we don't know what the follow-up would have been, right? We didn't know if somebody explained to him where the seatbelt was, if he knew about the laws, if there was a sign that says there's a seatbelt here, whether they were sitting in the front seat or in the back. We don't know any of those things. All we know is, yeah, I've been in an RV and I use a seatbelt. Hey, and that's all I'm going to answer about that. So I think that's just a little unfair. And the other thing that Mr. Rincon just wanted to state, and that's that he didn't instruct anything regarding factual. Well, that seatbelt issue right there, that was factual. Did you ride in a RV with the seatbelt? That's clearly factual. Whether there's an indemnity agreement between two entities, well, that's factual. Okay. Were you aware that double brokering was unlawful, or that unlawful brokering was prohibited by the Federal Motor Carrier Safety Act? That's factual. And then he claims that we were going to ask him hypotheticals about those articles. We weren't allowed to ask him anything. So the fact that he's hypothesizing we would have asked hypotheticals is kind of a hypothetical in himself. Can he name one hypothetical that we've asked regarding those articles? He can't. If he can cite to some part in the deposition where Mr. White asked him a hypothetical about those publications, he can't find it because we weren't allowed to ask him anything about it. So, with that, Your Honor, we think we should be able to depose Mr. A again on these 4 limited topics. Okay, that's what we're asking for. We're not asking, oh, we forgot something, so we're going to plow some other ground. These were all things that were asked in his deposition that he was instructed not to answer. And we are perfectly fine with the court limiting that in their order. Hey, these are the 4 topics the plaintiffs want. This is the topics that the representative will have to be produced on. And with
Your
that,
Honor,
thank you.
Your Honor, a 10-second rebuttal, just 10 seconds.
Yes, sir.
The issues relative to insurance, indemnity agreements, double brokering, I never prevented counsel from getting into factually the existence and contents of whatever documents have been produced. What I addressed via an instruction, and it was very limited when it seemingly tries to get into interpretation, opinions, conclusions of coverages, the force and effect of indemnity agreements, and commenting on opinions in publications not disclosed, not mentioned in the deposition notice about double brokering. They could have gotten into that. They made a strategic choice not to, Your Honor, and we stand on the rest of our objections and our filings.
All right. Thank you, gentlemen. I do, of course, I always hate to do this, but with these late filings, I'm sure what is in, I say late, I just mean I haven't had time to review the plaintiff's additional reply. And I feel like I've heard it today, but I do want to review the filing by Mr. Rincon yesterday and Mr. Villanueva, your supplement today. So that's going to take a minute. I am going to try and get you a decision before the end of this week, though.
Your Honor, and if I just may, and I speak collectively for everyone on this, we have been working very hard on this case. We're in depositions, and to the extent I couldn't get a response in sooner, it was just because it was physically impossible for me to get a response in sooner.
No worries. I didn't actually start looking at what had been filed until Monday. And so that's when I think I started asking if we had a response. So honestly, I wasn't looking for it anyway until late Monday. But now that I have your pleadings complete, I'll review that along with today's hearing. And like I said, the court is going to be operating remotely next week. So I want to try and get this taken care of before we hit that next week in the holiday. What I am seeing here, though, as well, well, there was a couple of questions, and now that everyone's here, I thought we still had a motion to compel, Landstar's motion to compel.
Yes, Your Honor.
Okay.
At Landstar's motion to compel, you issued an order for the depositions to be held by today.
Right.
Had everything scheduled, but we had to cancel one of the depositions. It's now being held on Friday, so I filed a motion on Monday just to extend your deadline 30 days.
And that's the one I was looking at, just in looking at these entries. Is everybody, I saw that you all
No
are
opposition, Your Honor. No
Okay.
opposition.
Okay. All right. So we can go ahead and do that. That's what I was asking. I saw the motion, you all were working on it. So if you all will forward an order on that as well.
Yes, Your Honor, I'll get that over to you today.
Okay. Okay. We're not set again for anything until September. So of course, if there's anything that requires a hearing, please request it with Ms. Hernandez along with your filed pleading. Thank you for your arguments today. If there's nothing else, then you all are excused.
Thank you, Judge.
Thank you.
Your Honor.
Thank you very much. We're going to have another fairly lengthy hearing on page 6, Rosa Maria Salcedo de Alonso case. So to the extent we can kind of knock out, I see Mr. Garcia, a few of these cases that may not take as much time. Where can we go next, Mr. Nunez?
Next, Judge, page 4. Pablo del Rio, we have both attorneys here, I believe. Calling docket number 2022 DCV 0151. Pablo del Rio et al. Versus Lorraine Herrera. Announcements, please.
Joe Garcia on behalf of the defendant, Lorraine Herrera, Judge.
Good morning.
Good morning.
Good morning.
Ms. Ross, did you make an announcement?
Yes, Your Honor. Do you need me to announce? I'm counsel for plaintiff.
Yes, please.
I'm counsel for plaintiff Pablo del Rio and Alma Cabos.
All right, Ms. Ross appearing on behalf of plaintiffs, final status conference. How are we doing on this case?
Your Honor, we do have a hearing set for the 10th of July. A motion to strike on my side and a motion for to admit late filings on plaintiff's side. So I was thinking that maybe we should take this up at that time, Judge. And that
Okay,
way you can hear what our arguments are, and then we can figure out where we're at for trial on August, or late August. I think it's the 30th. I'm not sure.
right. Yeah, that's certainly when it's set for hearing. So unless we have something else, you have your final civil pretrial after that. We'll see you on the 10th.
Okay.
Anything else, Ms. Ross?
No, Your Honor.
Thank you very much. You all are excused.
Thank you,
Thank you.
Judge.
Thank you. Who's next, Mr. Nunez?
Page 5, Judge, top of the page.
Mhm.
Calling cause number 2023 DCV 0040 Jasmine Silva individually et al. Versus Albino Rangel Ramirez et al. Announcements, please.
Good morning, Your Honor. Rolando Morales for plaintiffs.
Good morning.
Good morning, Your Honor. Rebecca Alvarez for early trucking transport and Albino Ramirez.
Okay, this is a scheduling status conference. It looks like that may have been reset from back in April. Well, how are we doing on this one? Let me see. I see attorneys. Are we missing anyone?
I'm covering for Ms. Levinati, Your Honor.
Okay, thank you. All right, are we ready for a trial date in this case?
I believe so, Your Honor. We do need to take depositions in this matter and mediate the case. We could probably fit that in before the next trial setting.
Okay, so we don't have a scheduling order or anything like that in place. So what I'm going to do is set you about a year out. I don't know why I'm thinking maybe we can do something shorter, but year is kind of standard. So we're looking at June 2025. Makes me a little nervous to say that. June 6th, we can do June 6, 2025. Your docket call will be June 4th. You're looking at a final civil pretrial, either end of April or May 7th. I'm not sure how the dates will fall, and that will be the mediation deadline will be the day before that. If you all will select and agree to a mediator included on the scheduling order, get us our scheduling order signed off on by you all, then we don't have to have our entry hearing in 2 weeks, but we will be set for that. Is there anything else I can, you all need from the court?
Nothing further from the plaintiff, Your Honor.
Ms. Alvarez?
Nothing from defendants, Your Honor.
Thank you for your patience. Y'all are excused.
Thank you.
All right. Who's next?
Judge, page 5, calling docket number 2023 DCV 3330 Credit Acceptance Corporation versus Gerardo Reese Jr. Announcements, please. Ms. Bailey?
Adrian Bailey?
Yes, ma'am. Hello, Mr. Bailey? That's all we have pending, Judge, that and the pro se. And I think
Judge, I apologize. I was driving and wasn't able to get to my mute button.
Okay, well, we've just called your case. Are you in a position to be able to?
I am. I just pulled off the side of the road.
All right.
Judge, my name is Adrian Bailey. I'm here on behalf of Credit Acceptance, and we're seeking a default judgment in the amount of $16,090.12, plus cost of court of $454.35 and post-judgment interest at 8.5%. This the defendant was served on October the 13th, 2023. Our records do not show that any answer has been filed. It resulted is a deficiency balance on a repossessed automobile. Originated on November the 12th, 2021. The balance at the time of the repossession was $39,976.81. There were some costs of repossession that were added to that, $40,679.81. After all credits, offsets, payments, etc., were applied to the account, there is the remaining balance of $16,090.12.
Mr. Bailey, let me just interrupt you there. It looks like we were set back on June 5th for a default. Were you the one that was here on behalf of Credit Acceptance Corp?
Judge, I was not.
Okay, so I may be incorrect because I don't have an independent recollection of that June 5th hearing, but I'm certain that if it was reset Unless you all were a no-show, notice on defendant was the purpose of the reset, so that there would have been sufficient notice of today's hearing. And I'm seeing that a notice of hearing was not sent out until June 20th. So that's only 6 days ago. We're going to try this one more time. 30 days from now. So we're looking at July 24th. We're going to do July 24th as a reset of today's default hearing. Ms. Hernandez, our court coordinator, or actually you, if you prepared the notice last time, if you will do that immediately so we have some type of documentation if the notice comes back, or at least that we could have time. Let me ask, have we had any contact from Gerardo Ruiz?
No, Your Honor.
Okay, so if you will just do that kind of quickly, I think we can turn it around in 30 days. In fact, it should, be very quick.
And that'll be July 24th at what time?
At 10:30 a.m.
10:30 a.m.
Mhm.
Excellent, Judge. Thank you very much. I apologize for wasting your
worries.
time.
No worries. We'll see you next time around. Take care.
Thank you, Judge. Bye-bye.
Okay. Let's go ahead and give Miss Deborah a bit of a break, because we're going to have I imagine a lengthy hearing. Is there anything else? You said we had a pro se, Mr. Nunez?
Yes, ma'am. If you give me a second, I'll see if he's on. I've got
What case is it on though?
It's on page 2, Judge.
Uh-huh.
2024 DCV 0487.
Okay. Let me see. And this is the one we received the email on, right?
I'm not sure, Judge.
Has Mr. Benjamin or anyone from his office been here?
No, ma'am, not that seat.
Okay, let's call this one very quickly.
Yes, ma'am.
Is Mr. Alvarez, is he the Samsung?
It's Mr. Alvarez, versus Felix Alvarez versus Arturo Alvarez, Judge. I'm not sure if it's the same son. I'm not sure if it's him
Who
or
is
not.
this individual that's here?
Sir, who are you, sir? Hello? Can you hear me, ma'am? ¿Me oye? ¿Me puede escuchar?
All right, let's go ahead and take a break now so we can figure out who that is.